So, distinguished guests, ladies and gentlemen, first of all, a great pleasure for us here at the Bavarian representation to have you here, and from this point of view, it's just to look in a completely sold out stadium, so very good for us. Tonight's evening brings together key voices from across Europe to reflect on one of the most pressing challenges of our time: how to shape a digital future that is competitive, innovative, and respectful of fundamental rights. It sounds like a magic triangle. As Bavaria's voice in Brussels, we are proud to host this high-level debate in cooperation with the European Data Protection Supervisor, Mr. Wojciech Wiewiorowski, the German Federal Commissioner for Data Protection and Freedom of Information, Mrs. Luisa Specht-Riemenschneider, and the Bavarian Data Protection Commissioner, Mr. Thomas Petri. So thanks for all partners for their commitment and also their collaboration. And from our German perspective, it's also a big honor to have Klaus Müller here, the president of the Bundesnetzagentur. Bavaria has long been a strong advocate for a digital Europe that combines technological leadership with legal certainty and trust. We believe that data protection and digital innovation are not in conflict, but reinforcing pillars of a resilient and value-based digital economy. The European Union has taken bold steps in recent years, from the Digital Services Act to the AI Act, to define a regulatory framework that reflects our shared values. But as these frameworks evolve, so must our dialogue. That is why tonight's exchange is so important. We invite you now to engage openly, to challenge assumptions, and to explore how we can ensure that Europe remains a place where innovation thrives and where rights are protected. Bavaria, as a region with a strong industrial base and also a dynamic digital ecosystem, is deeply interested in the success of Europe's digital transformation. We see a need for a regulatory environment that fosters innovation while safeguarding the rights of individuals. Events like this one are essential to ensure that the voices of regulators and also citizens are heard, and that we move forward together with clarity and purpose. So to sum up, thanks a lot for being here, and have fruitful discussions now and hopefully an inspiring evening.
Lieber Herr Wiewiorowski, liebe Frau Prof. Dr. Luisa Specht-Riemenschneider, lieber Herr Professor Petri, liebe Teilnehmerinnen und Teilnehmer, meine Damen und Herren, Ihnen allen ein herzliches Grüß Gott in der bayerischen Vertretung in Brüssel. Ich freue mich, dass diese hochkarätige Veranstaltung nun zum zweiten Mal stattfindet. Denn das Thema Datenschutz ist mir als bayerischem Innenminister besonders wichtig. Daher vielen Dank an die Organisatoren, Herrn Wiewiorowski, Frau Prof. Specht-Riemenschneider und Herrn Professor Petri, Ihre Mitarbeiterinnen und Mitarbeiter sowie das Team der bayerischen Vertretung. Die Datenschutzgrundverordnung sorgt seit nunmehr 7 Jahren für europaweit einheitliche Regeln zum Schutz personenbezogener Daten. Bürgerinnen und Bürger profitieren hiervon ebenso wie Unternehmen. Denn nicht nur der Grundrechtsschutz findet besondere Geltung. Auch Unternehmen in der Europäischen Union heben sich im weltweiten Vergleich durch das hohe Niveau des Datenschutzes hervor. Gleichzeitig sollen die DSGVO und der Datenschutz aber nicht als Hemmnis für Innovation und Wettbewerb wahrgenommen werden. Hier gilt es, pragmatische Lösungen zu finden, damit Datenschutz und digitale Entwicklung Hand in Hand gehen können. Außerdem muss die Vereinbarkeit der DSGVO mit den zahlreichen neuen EU-Rechtsakten in Bezug auf Daten und Digitales geklärt werden. Dazu ist eine ineinander verzahnte Umsetzung und Anwendung erforderlich. So werden Innovation und Wettbewerb nicht durch Rechtsunsicherheit gebremst. Hier hoffe ich auf mutige Schritte seitens der Kommission, insbesondere hinsichtlich der von ihr angekündigten Fitnesschecks und der angekündigten Strategie für die Europäische Datenunion. Meine Damen und Herren, deshalb ist der heutige Austausch besonders wertvoll. Ich wünsche Ihnen allen viele Erkenntnisse und interessante Gespräche.
Guten Abend, meine Damen und Herren. Es ist mir ebenfalls eine große Freude, Sie herzlich willkommen zu heißen. Mein herzlicher Dank gilt der Vertretung des Freistaats Bayern bei der Europäischen Union für Ihre Gastfreundschaft. Dankeschön. My name is Olivier Rossignol and I am the Head of Information and Communication at the European Data Protection Supervisor, EDPS. It's an honor to guide you through this high-level debate on competition, innovation, and data protection. Let me begin by thanking our co-organizers, the German Federal Commissioner for Data Protection and Freedom of Information, and the Bavarian Data Protection Commissioner, for joining forces with the EDPS to make this event possible. And of course, our sincere thanks go to our generous host, the representation of the Free State of Bavaria to the European Union. Before we begin, a few housekeeping notes. This event is being recorded. You see the camera in the room. But it's not live streamed. It means that the recording will be available a few days after the event. During the panel discussion, there will be an opportunity for questions from the audience, but please ask your questions at the end of the discussion. And finally, after the formal part of this debate, we invite you to stay with us for a reception with food and drinks. We are now delighted to welcome our first keynote speaker, Katarzyna Prusak-Górniak, head of the Digital Affairs sections at the Polish Permanent Representation. Ms. Prusak-Górniak brings extensive expertise in the EU digital policy and plays a key role in the work on cybersecurity, data protection, and digital transformation at the European level. Ms. Prusak-Górniak, the floor is yours.
Good afternoon, and first of all, let me thank you very sincerely for having me here and for all the co-organizers for organizing this very important event. And let me share with you some insights from the side of the Polish presidency still ongoing for 1 month. I remember I was being here in this very much building presenting our priorities, especially on the cybersecurity forum before the Munich conference, and I'm glad that most of the priorities we were able to deliver. The TT Council will be this Friday, so please keep your fingers crossed still for us, and still 1 month to go for the presidency. And this is the Polish presidency in Poland. We are in a special situation as within my unit and within the Ministry of Digital Affairs of Poland that I'm representing here in Brussels, we combine 3 different working parties. We are responsible for 3 working parties. That is the Working Party for Telecommunication and Information Society, the one who was responsible for negotiations of the AI Act, EIDAS, Data Act, Data Governance Act. But we are also responsible for horizontal working party for cyber issues, the whole cybersecurity agenda. But what is very unique as well for the Working Party on data protection. And having this special position, we wanted to use it also in the spirit of breaking down the silos and connecting different communities in very important discussions that we believed were of utmost importance for now. So First of all, we already organized a discussion, joint debate between the Cyber Working Party and the Data Protection Working Party on the idea of single entry point for incident notification, to also put into discussion the ideas how we can simplify and lessen of the administrative burden for all the stakeholders who fall under the scope of the legislation that we have adopted and is already in place or soon be in place. So there was this exchange, and we also heard from stakeholders that indeed having one point when you could report data breach notifications and incident notification would really make a difference. This is also on the basis of a very good example from Denmark, when they already implemented such a solution, when through one point of one single entry, you can do all the necessary notification. So this debate was there. We are now working on a report to summarize the discussion, and still in June we will have the exchange between member states on the basis of this report. Moreover, on the second point, we organized also a joint debate between the Telecom Working Party and the Data Protection Working Party, this time on the relation between AI and the GDPR, and there were some very interesting outcomes of this discussion and some ideas how to make sure that those two regulations are implemented in a streamlined and aligned way. And I would like to share with you those ideas. So there was an idea to provide joint guidance on areas of intersection between the AI Act and the GDPR. For example, clarifications required on issues related to data minimization, bias mitigation, sensitive data, and accuracy. There was an idea put on the table to create standardized templates for fundamental rights impact assessments that complement but don't overlap with GDPR data protection impact assessments. There were also ideas on having regulatory sandboxes with active involvement of both AI and data protection authorities. There were also to develop shared IT tools and coordination platforms for real-time confidential data exchange. And what is also important, there were ideas to create joint guidelines and a single auditing framework for holistic assessment of AI systems. What was also underlined, it was the need to ensure cooperation between the AI Office, the AI Board, and the European Data Protection Board. And this was also underlined many times, that in order to have a streamlined and aligned implementation, both authorities from both sides responsible for the frameworks should really closely cooperate. Also, there was an idea to consider involving European digital innovation hubs to provide advice to private entities, and also to provide clarification to allow adapting the GDPR principles for training on large data sets. We will still continue to have these discussions within the working parties, within the time that we have. And we believe that this model for simplification and the spirit of simplification is really, really needed now, also underlined by many stakeholders with which we've been having discussions all over for the 6 months. So 1 month to go, still a lot to do. And we will be happy also to pass to our Danish colleagues, with whom we have very good collaboration within the trio. And last but not least, of course, we are also hoping, and again, a kind plea to keep your fingers close to finalize the trilogues for the GDPR implementation regulation. So hopefully still this month. Thank you very much and have a good debate.
Thank you very much. Our second keynote will be delivered by Klaus Müller, President of the Bundesnetzagentur, the German Federal Network Agency, who brings a vital perspective on cross-regulatory cooperation in the digital sector. Mr. Müller, the floor is yours.
Well, distinguished guests, dear ladies and gentlemen, thank you very much for this invitation, and it's a great honor to be here, and I'm looking very much forward to our dialogue. At this event, as well in our current activities in the context of evolving EU digital legal framework, points of reference to data protection authorities are very strong and even getting increasingly important. So I would therefore like to offer you the view of a telecommunications and digital market regulator, which is bringing maybe a slightly different angle on the topic of this event of competition, innovation, and data protection. Let me first of all start with setting out our approach to competition and innovation. We, the federal regulator, the Bundesnetzagentur, started out quite long ago as a regulator for the telecoms market, with the objective to establish and to maintain competition in those markets, the telecoms industry being a monopoly at that time, as you may remember. This was not only the case in Germany, but in very many countries. Well, competition happens to be one of the 4 objectives of the electronic communications framework, accompanied by the 3 objectives of investment, connectivity, and end user or consumer protection. Competition is therefore in our DNA. One of the other objectives is promoting investment and innovation. Some people may think that there is a trade-off between competition and innovation, and this is definitely true, but only to a certain extent, because we believe and experience that competition is driving investment and innovation, in fact, the best driver for investment and innovation there is. But only competitive pressure will incentivize the undertakings to outsmarting their competitors in terms of innovative products, services, prices, variety, and quality. So in line with the European Commission's new work program and their action plan, which is putting its focus on competitiveness of the European industry and Europe as a continent, this is best achieved when industries are governed by competition, leading to investments and innovation. So therefore, I would like to stress that competition is the foundation for the competitiveness of undertakings, industries, and also as a whole country. It is therefore more important than ever to have a framework that is supporting and promoting competition and innovation. So how does those data protection fit into this view? The existing sector-specific regulatory rules, the new digital provisions, and the data protection law are distinct legal frameworks, but are strongly interrelated and have definitely a number of commodities, such as the aim to protect individuals and their fundamental rights, or to increase users' consumers' choice. And in fact, as business models evolve and as data availability is key for the development of digital technologies, personal data and the rules applicable to its proceedings are becoming increasingly central. There are already prominent examples, such as the decision of the German Bundeskartellamt in the Facebook proceeding, that shows how strongly data protection is relevant to competition. And that is why a consistent and coherent application of the whole European framework is just so essential. We have to consider ways of promoting coherence among those different but interacting areas of regulation, bearing in mind the risk of their incoherent application at individual or social levels. So, with specific regard to the new EU digital legal rules, the interrelation is getting stronger and stronger. Digital legislation such as the Data Act, the AI Act, can only exist in conjunction with data protection. We have to think these rules together and make them work in practice. Most of the digital acts implicitly state that data protection regulation are not affected. So therefore the rules complement each other and the enforcement responsibilities exist side by side. Furthermore, the new digital rules aim to improve the availability and the use of data, or like the AI Act, presuppose this in particular. High quality data is fundamental to developing performant AI systems. Access to and the use of data, including that from public sector, is essentially for AI training and the development of trustworthy AI made in Europe. This won't work without the proceeding of personal data, whereby, of course, data protection must be preserved. It is not a question of data usage versus data protection, or which aim is placed over the other. There must be a balanced approach of a coherent and consistent application of the whole EU framework. Let's take the example of the AI regulatory sandboxes, which will play an essential role in promoting innovation in the implementation of the AI Act. So we, and Luisa and her authority will probably deepen it a little bit more, we are already implementing a sandbox pilot because there is no value for a startup receiving a positive signal from the AI authority if AI systems then violates data protection rules. According to the current considerations of the German government, the Bundesnetzagentur may play a central role in enforcement of the Data Act, the Data Governance Act, and the AI Act. As already mentioned, to ensure the successful implementation, it is from the early stages crucial to collaborate closely between the various players, as well at various levels. We need and we want to establish a new ecosystem of cooperation in order to ensure a coherent and consistent enforcement, reducing legal uncertainties and risks while promoting a data-driven innovation. Close cooperation is required between political players, businesses, academia, civil society, and, in particular, the relevant public authorities. At the national level last year, the so-called Digital Cluster Bonn, composed of the 6 federal authorities, including the Data Protection Authority, the Cybersecurity Protection Authority, and others, was established. The rationale behind was to provide for a forum where at a very early stage a general exchange and common positioning on general questions can be taken place. Close and trustworthy cooperation between the involved institutions is important for developing a common interpretation of the digital provisions, or to facilitate general guidelines that avoid dividing decisions or to reduce the number of coordinating processes in individual cases. A high level of cooperation and coordination is needed also on the European and even international level. For instance, we currently sense a great deal of uncertainty in the German market as to how to comply with the new AI rules, in particular with small, medium companies and startups. So we would like to counter this uncertainty by providing information and further guidance for market players and end users. We would like to do this together with the colleagues from the Digital Cluster in Bonn and, of course, in close coordination with the EU Commission and the other European authorities that are enforcing digital rules. Networks of competent authorities and the EC are currently being set up or already working. So within the European Data Innovation Board, for example, issues relating to the practical implementation of the Data Act and the Data Governance Act are discussed among the competent authorities. Considering the need for a consistent and coherent application of the EU framework and the close interrelation of the distinct areas of law, the exchange and cooperation between European networks will become necessary as well. In the future, it will be important for networks such as the European Data Innovation Board, the AI Board, or the European Data Protection Board to share the information with each other in order to better understand the views, the ideas, and the decisions. Maybe we can learn in this regard from the example of the Digital Market Act, where the cooperating in the high-level group views from the several groups and bodies such as the European Competition Network, the European Data Protection Board, and BEREC are brought together. Let me close by saying that such a new ecosystem of cooperation can ensure that the legal framework is implemented in a coherent and complementary manner. It will allow us all to develop a common understanding and coherent approach in order to find ways to foster competition, innovation, and data protection all together. Thank you.
Thank you very much, Mr. Müller. The third keynote address of tonight will come from Irene Nicolaidou, Data Protection Commissioner for Cyprus and Vice Chair of the European Data Protection Board, whose leadership plays a central role in ensuring the effective and harmonized implementation of the GDPR across the EU. Ms. Nicolaidou, the floor is yours.
Thank you very much. Good afternoon to all, dear ladies and gentlemen, dear colleagues. It is my pleasure to be here today and to take part in this high-level debate on competition, innovation, and data protection. Before diving into the content, I would like to thank all the people involved in the organization of this event and for creating this opportunity to exchange views, not only on the needs and challenges, but also on strategic priorities, future opportunities, and avenues for cooperation. Today, I would like to dedicate special attention to the concept I have just mentioned, cooperation. Cooperation across regional and national borders is at the heart of the European Data Protection Board's work and one of the 4 pillars of our 2024-2027 strategy. Every day, European data protection authorities work together to ensure the consistent application of EU data protection rules. The changing digital landscape and the new EU digital laws have pushed us to take this cooperation a step further. Let me take the example of the DMA, as mentioned before by Mr. Müller. The DMA and the GDPR pursue different objectives. For the GDPR, this is the protection of individuals with regard to the processing of personal data for the GDPR. For the DMA, the objectives are constatability and fairness of markets in the EU digital single market. In particular, the DMA addresses the gatekeepers' privileged access to large amounts of personal data. It lays down specific rules of gatekeepers, for example, of advertising practices, on consent requests, and on the cross-use of personal data. This has, of course, data protection implications, and both the DMA and the GDPR may cover processing activities carried out by gatekeepers. This is why we are working on joint guidance with the European Commission on the interplay between the DMA and the GDPR. The same goes for the other digital regulations, the Digital Markets Act, Digital Services Act, AI Act, Data Governance Act, and Data Act, built upon the GDPR, and the adoption of these acts requires seamless collaboration across regulatory bodies from different fields. The EDPS actively engages with other regulations, such as the EU AI Office, the high-level group of the DMA, and the EU Board for Digital Services to ensure consistency of application between the GDPR and these acts. And we also cooperate closely with the AI Office in the preparation of guidelines on the interplay between the AI Act and EU data protection legislation. Personally, I'm deeply convinced that data protection and digital regulation benefit from a cross-regulatory and interdisciplinary approach. Our shared objective is to develop innovative technologies that are responsible and uphold EU values and fundamental rights. Facilitating the exchange of expertise and best practices among relevant regulators is the best way to ensure this outcome. To this end, and to support the dialogue between the PAs and other regulatory bodies, the EDPS has created the cross-regulatory interplay and cooperation as expert subgroup. The main aim of this subgroup is to clarify the links and build on synergies between the regulatory frameworks of data protection, competition, and consumer protection law. In addition to the examples I already mentioned with the guidelines when relevant, the EDPS already systematically opts for a cross-regulatory approach when adopting opinion and other documents. In December 2024, for example, we adopted an opinion on the use of personal data to train AI models. These opinions look at, first, whether AI models can be considered anonymous, Second, how legitimate interest can be used as a legal basis for developing or using AI models. And third, what happens if an AI model is developing using personal data that was processed unlawfully. In the course of drafting the opinion, the EDPB met with the EU AI office and looked on board its views. Last year, we also adopted an opinion on consent or pay models used by large online platforms. In this opinion, we explained that in most cases, these platforms will not be able to comply with the GDPR. If users can only choose between consenting to processing of personal data for behavioral advertising purposes and paying the fee for a privacy-friendly version, individuals should be given a third option, namely an equivalent alternative without behavioral advertising. As many of you know, a few weeks ago, the European Commission adopted a decision on meta consent or pay models, according to which the consent or pay model introduced by Meta in November 2023 fails to comply with the DMA. According to the Commission, Meta breached the DMA obligation to give consumers the choice of a service that uses less of their personal data. The EDPB welcomed the Commission's decision as it aligns with our opinion. This case perfectly illustrates how approaching the same issue from different regulatory angles, data protection and competition law, creates a more comprehensive understanding. This is the only solution to allow the development of innovative technologies and a competitive market while keeping individuals and the effective protection of their rights at the center of our work. To do so, it is crucial that we continue working together and ensuring a cross-regulatory and interdisciplinary approach. With all this in mind, I'm looking forward to exchanging views and learning more about the experiences of top experts of competition, innovation, and data protection. I wish you a very interesting and fruitful discussion. Thank you very much.
Thank you very much. Please join me to thank once again our distinguished keynote speakers for setting the scene. Now, it is time for a panel discussion, which will explore further the need for coherent and consistent implementation and enforcement of the GDPR and the EU Digital Rulebook. Therefore, let me introduce our panel moderator, Ulrich Baumgartner, leader for the region Germany, Austria, and Switzerland at the International Association of Privacy Professionals and co-founder of the law firm Baumgartner Baumann, expert in data and IT law. Mr. Baumgartner, the floor is yours.
Good evening, and it's a pleasure to be here. I would ask all the panelists already to come on the stage, please, and I will briefly introduce you and kick off our discussion. So we will continue exactly with all the topics that you just heard here, and try to get the regulators' view, the academia view, the business view, my view as a lawyer dealing with data law for more than 20 years. And we'll have 2 rounds of discussions here among the panelists, and then you will have the floor. You will have 15 minutes to, at least 15 minutes, I can promise, to ask your questions to whoever you want, and please do take the opportunity and let's have a lively discussion. And before we start, I have to say I've never been in a room with so many regulators and supervisory authorities, so I'm absolutely scared as a lawyer. But at the same time, I feel safe because I learned I'm on the Bavarian soil here, so I feel at home, it's safe. So yeah, let's start the discussion, and I stay here and introduce our panelists from here briefly. So ladies first, we have Luisa Specht-Riemenschneider, the German Federal Commissioner for Data Protection and Freedom of Information. BfDI, I will explain a little bit in a moment what her role and responsibilities are for those of you who were not familiar with the German supervisory system. Then we have Moritz Hennemann, a professor from the University of Freiburg. That's a nice and very beautiful town in the southwest of Germany with an old university. He's holding the chair for private law, information law, media law, and internet law there. So welcome, Moritz. We have Axel Voss, I guess, who doesn't need any introduction. The father of digital regulation in Europe and a member of the European Parliament. Welcome, Mr. Voss. We have Alberto Di Felice, legal and policy advisor of Digital Europe. So he's bringing us the business perspective on this panel. And obviously, Wojciech Wiliorowski, welcome to you, European Data Protection Supervisor, and doesn't need any further introductions, I guess. So the topic is basically what you just heard in the keynotes. I think a lot of what we are going to discuss now has already been addressed. It will be all about how does the EU Digital Rulebook play out in practice? How does it work? Does it work? Can it achieve all the objectives that the legislator wanted to achieve with these laws? How does it interrelate to the GDPR? That's my favorite topic, very difficult one, as you know. And yeah, and then you invited to ask questions whenever you want. I probably want to kick off the debate with a kind of a, yeah, hopefully it's not too negative, but I just came across in the plane a statement that the European Commission put out last week. In their paper on the public consultation on the European Data Union strategy. And there's one sentence in this paper which is really dark, I guess, and could be a starting point for our discussion to brighten it up a little bit. The Commission says, I quote, "The regulatory landscape on data use in the EU is marked by a complex mix of general and sector-specific laws, the interplay of which often is hard to understand for business, is enforced by different bodies of authorities, creating inefficiencies and uncertainties for businesses and public administrations." So this is what the Commission apparently thinks about our topic today. And this will be our first action item now. Switch. And is this... Yeah, okay. So, ladies first, obviously, Luisa. So, the first main topic that we want to discuss here in this panel is the opportunities and the challenges of the European Digital Rulebook. The second round of discussion will then focus a little bit more on the GDPR. So we will address that question. Don't worry. But the first round of discussion will be more around. Does it work? Is the EU digital rulebook what we all expected it to be? Does it play out can it play out in practice? Does it play out in practice to the extent it's already in force? And Luisa, my first question to you, as you're kind of a professional of cooperation in Germany, because we have that a federal system of supervision in Germany, as most of you certainly know. So we have 16 different state-level regulators for data protection, and then we have Luisa's office as the federal data protection regulator. And obviously, that is something I would assume requires a lot of coordination already to date, and will definitely require more coordination going forward. So what is your view on the digital rulebook? What is good, what is bad, and how can you see this playing out in the future in practice, particularly looking at the authorities, the different authorities involved, and how they cooperate?
Yeah. Well, let me begin with your quote. Because I would really agree to a certain extent. I would not say it's that bad, but there are some things which I really want to focus on, because one of the key challenges I observe as a regulator is really legal fragmentation. When we look at all the digital acts, the AI Act, the Digital Markets Act, the Data Act, the Data Governance Act, the GDPR, then all those rules might be fair in their own space, but there is always one sentence in all these digital acts which says that the GDPR remains unaffected. And I think this is not true, because as soon as you process data, and as soon as you make a law on processing data, it doesn't matter if it is called the DMA or the Data Act or the Digital Governance Act, as soon as you make a law which says, yeah, data is processed, then the GDPR is affected. And this gives really rise to legal uncertainty. When I talk to data processors, then this is the main aspects. Well, we want to comply with the law, but we don't know how. And there are really questions which I myself am struggling to find an answer to. For example, can these new acts reinterpret core GDPR concepts such as the purpose limitation or legitimate interests? What's the answer to this? Of course, a data protection authority would say, no, the GDPR must remain unaffected. But these questions arise, and we need to find answers to these questions. What happens if the objectives of data innovation and data protection come into tension? There is this tension, and we need to find an answer. What should be done to really make innovation happen and to protect data at the same time? We need to give really concrete answers, not only saying, well, yeah, the laws want both, but we don't know how. So we have the responsibility also as regulators, being regulators, to find answers which work in practice. And this is not an easy job. I believe, therefore, that such questions cannot be left entirely to ex post coordination by regulators. There is a need for greater legal clarity and upstream alignment between the legislative instruments themselves by the legislator. I'm sure Axel and Moritz, you will elaborate also on this topic. But this is just my point of view. We as being regulators are being left alone to a certain extent, and I think there could be in the DMA, in the Data Act, in the Data Governance Act, there could be more legal certainty. However, we can do as being regulators is to give guidance on how we think the legal interplay should be interpreted in a coherent manner. And the EPB is very active in this field already and has had the interplay between the GDPR and the digital acts as a focus topic in its current strategy. And I think this is the right way to go. So this being said, these were the challenges I see, but there are also opportunities. I really see big opportunities, not only from an economic perspective when I think about the digital rulebook, but also when we ask the question, what does Europe want to stand for? Do we want to foster innovation, doesn't matter what it costs, or do we want to have a unique selling point? And our unique selling point, from my point of view, can be really a fundamental rights-based innovation, so that we really have both data protection, fundamental rights protection, and innovation. And this does not work when we now strike back all the regulation we have, but to the contrary, we just need to we need to make the rules, the laws more coherent, and we need to focus on the interplay between the different laws. I also see that there is the need for the regulators to work together. Klaus, you did focus on that topic. I really can underline the Bonn initiative, where we try to work together on a voluntary basis. But what could be also part of a digital rulebook is to find laws or some laws which really push forward the cooperation between the different regulators, and we also had that in the EDPB today to make that more clear, when they should cooperate, how they should cooperate, how data can be processed when they cooperate, for example. But let me leave it that way. I see big challenges, but I also see big opportunities, and when we really manage to have a better coherence between the different laws, then I think that Europe can really have a unique selling point in fostering fundamental rights-based innovation.
Thank you, Luisa, for this regulator's view. That's interesting to hear that you feel left alone by the legislator. We have to talk about this, but I'm not surprised by this statement. Yeah, Moritz, over to you. Basically the same question. So, does it work, the rule book? Can it achieve its objectives? You, as a representative of academia, you have a neutral view on that. So, what is your feeling? What is your what is the result of your examination of the status quo that we have? And we're going to look into the future in the second round of discussion. But just looking at today, what is your view?
Thank you very much. Looking at the EU digital rulebooks and looking at its objectives and its goals, good, very good. Looking at the concrete regulatory design, not alike. The concrete design leaves questions open. We have heard already that by Luisa Specht-Riemenschneider, but I'd sort of like to start with the positive things. The positive things of the EU Digital Rulebook, next to its objectives, is the fact that it's focusing on data use and data usability. It has a clear societal approach to regulation and a viewpoint and fostering a multidimensional viewpoint, not only focusing on consumers, not only focusing on businesses, not only focusing on the private sector, but focusing on the state sector alike. It's a 360-degree approach to data regulation between different actors and different conflicting interests that need to be balanced. It is focusing on individual gains, users, for example, within the Data Act, but also on collective responsibilities with regards to businesses or data holders being subject to data access rights by state authorities in cases of exceptional needs. What is wonderful from my point that it's strengthening users, which is not only an individual or a consumer, obviously, but also companies, especially small and medium-sized companies. It's excellent from my point that it's focusing also on the contractual layer, as all the different actors are connected by contracts normally, and the Data Act has rightly spotlight on the contractual layer and the contractual connection between the different actors, including also a standard term control for B2B data access and data use transaction. What does not work or what does not fully work? We have heard that clear decisions, legislative decisions, are missing with regard to the interplay of the GDPR, on which we will come back in a minute. Also, the relationship to the trade secrets is rather complex, and taking one example from the Data Act, where data protection is nowadays acting as a defense against data access rights, which was not the original thing one thought about, at least. The bigger problem is that the new EU digital rulebooks, to some extent, is missing clear incentives. If you look at the Data Governance Act, for examples, who wants to be a data intermediary or data altruistic organization if the only thing you can get is more duties and fines? I'm not too sure. And the numbers which have notified themselves or voluntarily registered are not too high at this moment in time. So no incentives, no leeway, even with regards to data altruistic organizations and their non-profit and common good perspective. What is also missing is one aspect which leaves the Data Act legislator openly to the member states is the data contract, the standard term control in data contracts in B2C scenarios, which are left to the national member states, which, at least from a German point of view, are not regulated in a precise way, only in a very general way as the general standard term control applies. And many decisions, many in contractual relationships, many imbalances are typically tackled by that instrument. And to say, a last point, one big elephant in the room is the question of private enforcement. We have many rules within the EU Digital Rulebook, in the Data Act, in the Data Governance Act, on public enforcement, which is not fully understandable, as we know that we have public enforcement within the data protection realm, but why a private-to-private data access right is combined with a public enforcement is not fully clear, at least from a starting point, as the Data Act is mainly targeted at private-to-private interactions and not targeted at data protection rules in that regard. And the problem is, in that regard, to sort of sum it up, that the balance between private and public enforcement is at least not spelled out clearly within the acts, leaving very much room for discussions on the national level. But to sort of end with a positive note, what is good is that it's a general data regulation. Data law has developed to a specific field of law where data protection law is only a big room within a house. A room through which you have to go quite often, and you can often not avoid, or you're not sure whether you have to go through, but it's only a room within a bigger house of rules focusing generally on data use in all its societal dimensions. Thank you very much.
Thank you, Moritz. Yeah, please. Axel Voss, when you look at this house with the different rooms now as it stands there, what is your analysis as of today? Has it played out as you intended it to be or wanted it to be, or what is your current analysis?
So, from my point of view, so good evening and thanks for the invitation. From my point of view, I would say it never turned in such a way we have thought, or I have expected, or I would like to wish to see it in a way. We are not living in sunshine days any longer. If you look to all these Trump fanboys in the US, you get a feeling there is a kind of an imbalanced situation, and here I think we need to do more. And this is now probably the time to decide, do we want to die in beauty, or do we want to have a kind of an added value making out of digital issues? So what we have exaggerated from my point of view is data protection. If I'm looking to Germany, and I know it's not your fault, this is hysterically approach on data protection, detailed, unpractical solutions. So where I would say, and it takes such a long time in clarifying everything, and then we are coming to the European level. Also here, I would say it lasts too long. We need now action, especially with the digital playbook. Yeah, it's wonderful if we are making our plans and ideas and writing new lists and but not having a kind of an transferring this into reality. The biggest mistake, I would say, in data protection has been that we are leaving all the interpretations to our member states. This is a kind of a harmonized approach, but every member state is interpreting this differently, and then we need another level on EDPB in finding a kind of a solution, but only for cross-border cases, and it's still is a kind of a differences in member states. This is something where I would say we need to change this immediately to come to one interpretation on a European level in a balance of competition and not only 150% data protection. We need now to take this risk if we would like to survive digitally. And that's why I think we have to rethink and to reinvent ourselves. Otherwise, we will totally dependent on companies from other states. And this is where we have to ask ourselves, can we achieve this, or is this already too late? Still, I would say we have a kind of opportunity now, but we can't have this 150% of data protection any longer, what is hindering a lot. If Louisa is changing now the approach in saying, now we are getting a kind of a service mentality, and you have a wonderful idea, yes, let's sit together, in 1 week we have a solution, and then we can build a kind of a new business model out of it, then it would be fantastic. But so far I do not see this. But this cooperation you have mentioned, yes, but we need to do this immediately. And we can't do this in, let's wait, we have another year or whatever. No, we do not have.
But when you say we, you mean the legislator, right?
Yes.
Because the problem that I'm seeing, a problem is the wrong word, but the reason why we have this very strict interpretation of the GDPR is in my view, primarily the European Court of Justice case law that we see in the last years. It has a very, very strict interpretation of principal concepts of the GDPR that makes it almost impossible for a regulator or a national court to get around it. Yeah, and so. In my view, this is something only really the legislator can solve at the end of the day.
But don't get me wrong, I do not want to give up data protection, but in the way we are dealing with it, this is a kind of a no-go. And the European Court of Justice in this regard is also a kind of a problem. But then we, so they are more acting like an activist and not like a balanced approach on all of this. Article 8 in the European Fundamental Rights Charter, I think it's worded around 2000, but it's already old wording, and it has nothing to do with the data or innovation reality we are in. So even I would say we have a kind of a problem with some elements. In a data-driven world, is it really wise to delete data? Is it really wise in an AI technology where we would like to achieve results, what is gender balanced, what is non-discriminatory, what is non-biased? Is it really wise not to provide personal data for this? I would say no. And that's why I think we need a different approach, more in a, let's balance these better, and just using data for one specific purpose. With AI, we have another reality. And if we are just, because of this, coming not to a kind on an innovative creation of AI models, then we are out of the game. And this is also the same situation with health data. Of course, we can probably anonymizing or pseudonymizing these, but if you would like to keep research in Europe, then you need to have a lot of health data for doing research. Otherwise, they will all step out, and this is not the intention of a GDPR. This has not been our intention, and that's why, of course, there are exceptions, but then the elements are not handled in a kind of a positive way from my point of view. And here I still think we need to reorganize or to rethink all these elements, how this is fitting in a world of a data-driven world where we would like, I hope so, still to play a role. And that's why I think even with the AI Act, I would say to get more clarity in this, let's say, yes, you can use personal data for training your algorithms. I do not see any harm, especially if they have the data already in the company. So that's why I'm asking more for anarchy and revolution, and this might irritate someone who is coming from the CDU, but I think we won't come forward if we are not looking to the innovative reality.
Thank you. Alberto, turning to you and as the business representative here, what is your view? And I would also like to ask you a specific question. How important do you think is the aim of the digital rule book of sharing data, of making data accessible from a business perspective?
Thanks a lot. So first of all, I want to say I'm moved by your reading of that passage from the Data Union Strategy Call for Evidence, because we told the European Commission sort of 5 years ago, and DG Connect specifically, and they told us that we were exaggerating things. So I'm glad to see that that our realization of what's been happening has been different. So I think there's been quite a lot, obviously, in the past 5 years. The problem is we don't know how bad it's going to be yet. Some of the stuff that's been put in place is not applicable yet. So notably, the Data Act, AI Act are not applicable yet. And I would say there's been two different types of digital regulation that's been coming the past 5 years. One, I would say, is purely digital. So DMA, DSA really targets specific players. There are specific problems with those regulations, but they are purely digital. Another batch of digital regulation isn't really digital at all. It actually targets the entire economy. The Data Act and the AI Act in particular target a lot of manufacturing industries that are the stronghold of European industry. And this is Bavaria practically, so I think it's particularly important to know that. And so it's not just a few people who have to deal with this, we call it the tsunami of regulation, which really is a misnomer, because the tsunami hasn't happened yet, or it's just starting to happen. So far, we've only seen the underwater earthquake miles from the shore. People have a vague notion that someone in Brussels adopted new regulation that they weren't really following as businesses, and now they have to start to comply. So they're starting to see the wave rising. One of the things that they are starting to see, for example, is that manufacturing companies have to renegotiate all their data usage and data sharing contracts, all of them, because the Data Act forces them to have provisions in place for how they use their users' data, as well as to have contracts in place for third parties, other companies that might want to access the data from their connected devices. So they're having to do that because of European regulation. Another great example is, if you're a medical device manufacturer, which thankfully we have quite a few in Europe, right now you'll have to comply with the GDPR, of course, with the medical device regulations. You have to understand also how the European health data space applies to the data that's processed by your medical devices. You'll have to understand how the Data Act might be impacting how you have to share data with other companies. And also, of course, you have to understand how the AI Act applies to the AI that you use on your product. So that's a multiplication factor of 3, I would say, of regulation that applies to one specific company. Again, not a digital company by any means, it's a digitizing company. We have the pleasure of having a number of those within Digital Europe. They're the biggest growing part of our membership. So it's getting very complicated. So far, again, we've seen elements of the difficulty that we have in coming to grips with all these diverse use cases. The GDPR has been a wonderful terrain to test the limits of what companies can do. And we've seen that it's been difficult for all the reasons that other speakers have mentioned before. You know, there continues to be fragmentation, not only in enforcement, but in interpretation. And there continues to be, you know, various currents of thought as to how data protection authorities need to look at acting as, let's say, enabling to good, positive data sharing and data use cases. But now that complexity is going to multiply, because we're going to look at a scenario where any single individual company that's processing data, personal, non-personal, the difference is becoming more and more negligible. We'll have to deal with a multiplicity of authorities within each individual member state who will have to coordinate among themselves, and they'll all have to coordinate at European level. So I think we're looking at a very serious tsunami. And the problem right now is that this is happening at the worst possible time for Europe. We're not just talking about compliance from a theoretical perspective, we're talking about the economic future of Europe. Again, go back to my key message tonight. Key manufacturing industries impacted by this regulation. I don't need to mention the geopolitical tensions that we're facing. And at this point in time, tariffs, no tariffs, whatever, we're also adding huge uncertainty as to how they can operate in Europe and do the kind of digital innovation they need to be doing if we want to have digital champions in Europe and globally, starting from Europe going forward. So it's not looking great.
Thank you. Thank you, Alberto. Wojciech, last but very certainly not least, from a EU top regulator's perspective, what you just heard, would you agree? What is your view on where we are at the moment? And can you explain also a little bit what your initiative is aiming at with the digital clearinghouse that you have established to foster this cooperation that Alberto just mentioned, that we all basically mentioned, all the keynote speakers mentioned cooperation between regulators is important to avoid that fragmentation. So I think that's a very interesting initiative that you are having in your authority.
Thank you for the question. First of all, welcome at the meeting, which is already organized 5th time, I guess, and I remember very well in 2019 when we had the meeting here in July 2019 with Andreas Mund presenting the first ideas of cooperation of competition authorities and the data protection authorities in Germany in practical world of existing GDPR and being enforceable. And also having the Secretary General of the Commission listening to that and being also the part of the panel. I'm saying that to say that this is not the new discussion, and this is not the discussion which we just start, that we have as the regulators, we have quite a history of cooperation between the silos that exist. And unfortunately, the digital rulebook partly creates this silos approach. Of course, that was not the idea of those who are creating that. I would not want to go to the custom to saying, oh, we said years ago that it will look like that. But it's somehow true that EDPS, in its opinion, said that the model of enforcement of the rule book is at least as important as the ideas that we want to achieve. So having good things in our mind when we started to work on the rule book, we have to say that the situation is complicated, although based on theoretically logical solutions. So we have the base element, which is the data protection law, which is GDPR, and we have the approach from the competition point of view, from the services point of view, and two acts which we have a little bit more problems with, Data Act and Data Governance Act. Anyway, each of these acts create a kind of enforcement model and cooperation model between the authorities. I have to say that I was very skeptical when we were thinking about the high-level group in the Digital Markets Act. And I was wrong, actually, because this cooperation that involves five groups of regulators looks quite promising and gives quite good results. So when we are seated at the table and we are discussing the real work that we do, we go to the good solutions. I'm not sure if the answer to the problems of regulators is to have one regulator for all. There were the ideas like that. And that's not an easy thing. As an EDPS, I have two hats. I'm the Data Protection Authority, of course, but also according to Artificial Intelligence Act, I'm the Market Surveillance Authority for the EU institutions, bodies, and agencies. Of course, this is something which we just start. And the market that we are surveilling as Market Surveillance Authority is nothing in comparison with the national markets that the other regulators will work on. But I have to say that in my head, there is a kind of dialogue in between two regulators that are approaching to the same problem and try to find out how to deal with them. So for me, that's very practical, you know. I'm not the commission that is consisting of 18 persons, out of whom 3 are dealing with market surveillance and 6 are dealing with the data protection. No, that's in one brain. We try to find out how to approach the subject. So, anecdotes aside, the creation of one authority which is dealing with everything is not an answer. Most probably it's not an answer to create the authorities only on the European level. That was a very well thought decision at the beginning of the work on GDPR, when we said to ourselves, I mean, people working on the draft, people working later on the GDPR itself, said very precisely that 99% of cases are not even national, they are local. So they have to be done as close to the people as possible, because we hear about those cases that are all European, while, as I said, 99% is still local. But it all creates the group of different regulators in different jurisdictions, slightly overlapping, slightly approaching the same company from the different sides. Our solution, or maybe proposal of the solution, is as horizontal discussion as possible on how such a regulation should look like. And that's an idea of the digital clearinghouse. I'd like to remind that the work of the EDPS on the cooperation on the data protection authorities and competition authorities started in 2014. That was Peter Hastings who started it for the first time. And now we would like to provide the platform to not only exchange the ideas, but also to build the good practices between the regulators. I know that we have the ideas of cooperation in each of the parts, each of the chapters of the digital rule book, but we are still missing the horizontal approach to the regulators' work.
Thank you very much, Wojciech. That's a very good initiative, I think, and that's kind of what we need in the future. I think this clearinghouse approach, or this cooperation style. So, summing this up is difficult now because we have had different statements. But I think that the message is, I guess, clear. So, looking at what we have today, it's a mixed diagnosis. Yeah, there are pros and cons. There was a lot of good intention. Not everything has played out the way that everybody, I guess, intended. Now let's turn the view to the future. So let's talk about briefly, and I would ask you to really limit your answers maybe to 2-3 minutes, because then we have some time for the questions that I'm sure we will be receiving a lot of. Let's turn the view a little bit to the future and talk about what should change, what should the priorities be for the legislators, what should the regulators or want the regulators do, what can we expect also from case law and from the further development of data protection law. Let's also talk about a little bit about the interplay of the digital rulebook on the one hand, and the GDPR on the other hand, which I already mentioned is obviously in practice an issue. I mean, don't get me wrong, I'm a big fan of the GDPR, and you mentioned Trump earlier. I'm very happy that we have the GDPR and there's not some new government authority running around and collecting personal sensitive information from all other government authorities. So I think it's really good to have that law and to have that fundamental right, even and particularly in these days. But it's also very important, obviously, to strike this balance between the GDPR and the other rules and regulations. So, Louisa, coming back to you, if you had a wish for the next 5 years, what would you wish for?
Well, that's kind of easy. Following this discussion, I really realized that we got into detail very quickly. But what we have not asked, and what is never asked, is which kind of data processing, of data use, does this society want? And which kind of data use and data processing does this society not want? We do not discuss that. The legislator does not, we as regulators do not, and the society does not. And I want to accuse everyone because we need to have this discussion. It is a big difference if we have data processing, data use for only commercial issues, or if we have data use for medical issues. I myself have lost 2 close friends to cancer, and there is no one in this room who hopes for better data processing than me in the medical area while protecting data at the same time. We do have to have this discussion. This is my only wish for the next, let's say, half a year. And then we have a plan. And then we can move into the direction. But at the moment, let's be very honest, no one of us has a plan where this society wants to go. And please, let's make this plan and then go ahead. But not run into that direction with closed eyes and then make sure, okay, maybe it was the wrong direction, maybe it was good, but maybe there are some things which are not okay. Let's run into the other direction with our eyes shut. Please, let's make a plan and then go ahead.
Okay, thank you. That's that's a good wish. Talking about, again, Moritz, for you a question about the interplay of the GDPR, which a lot of you have stressed, and also our keynote speakers have stressed a lot. Just a short story. This morning I gave a webinar on connected car. And we had 3 hours for the whole topic, and 2 hours of these 3 we only discussed what is personal data. is a vehicle identification number personal? If not, if yes, what can I do to anonymize it? Yeah. How on earth can it be that we are still not clear on these fundamental questions of the GDPR and of all the other digital laws? Yeah, because you will never get data from a data holder under the Data Act if the data holder cannot rely on a legal basis under the GDPR that he feels comfortable with. He will not give you the data. If I would advise a data holder, I would say that's too risky. Yeah? That's it's a roadblock for data sharing that we have uncertainty in such fundamental questions. So, question to the academia: how can this happen? How can we solve this?
So. No master plan here, but what is sometimes overlooked is that the Data Act and the GDPR now together might actually pressure you to decide. As you might get a fine for granting access, but not being allowed to grant access by violating data protection laws if it's personal data, or getting a fine for not granting access because you should so under the Data Act because it's not personal data. Probably we do not have the time to wait for another 5 to 10 years and European Court of Justice decisions to solve these kind of cases, which do actually stress the need to distinguish between the two. And leaving aside the problem that mixed data sets and other ways are possible to not grant access and to not fulfill the idea of the Data Act in general. With regard to the interplay, first of all, at least from my perspective, of course we should interpret GDPR, rules and norms also in light of the general European regulators' approach of the on the basis of the data strategy, including legitimate interest and other aspects. It would be sort of at least from my point of view, not convincing to leave all the other acts and its goals totally aside if the GDPR leaves room for interpretation in that way. We have heard, and I don't want to repeat that this untouched is not too helpful and probably not true. I would totally agree that we have to ask legislators, as we have heard it very strongly, to point to specific rules allowing or not allowing data processing to give clear guidance and certainties and make legislative decisions, not leaving these decisions to the supervisory authorities or to those having to apply the rules. And we have had first proposals in that regard, for example, by the Vienna colleague Christine Wenderhorst, how this could look like. We should also be clear that the interplay would require some incentives also with regards to data protection law. I've mentioned the data altruistic organizations, data intermediaries already, and you could also talk about broad consent in the research area, which is a field which is obviously also open for member states to regulators. And as a last point, and I mentioned the general house, the general data regulation first, there are obviously some other buildings coming, and that's a sector-specific regulation which opens up the sphere to be more precise and concrete, and the European health data space is definitely going sort of into the right direction. In the long run, obviously, it would probably also be helpful to talk about lowering the duties where it's possible and tighten the rules where it's necessary, as standing still is probably not smart regulation. Thank you very much.
Thank you, Moritz. Yeah, applause is yours. Axel Voss, what can we expect if we look into the next 5 years? What's on the horizon? Can you give us a view into the crystal ball, your crystal ball?
So what we can expect is probably less than what I would like to have. So I think the time for action is now. We do not need new legislation, what takes again years and years, and so that's why I think we need to be faster, more speedy in everything what we are doing. Secondly, then it depends. If we would like to survive digitally and not being dependent on big tech right now, then we need to act even more radical. So implementing a kind of a Eurostack, having a European cloud services, having a European search engine probably, and also we have to mitigate the risks of social media for our children, for our democracies. So far, still I would say it's a wonder that democracy is still existing despite of social media. 13 years ago we thought, oh yes, social media is bringing transparency and democracy into the world, and now we are standing with the back to the wall. And here we have to act immediately if we would like still to live in a democracy and rule of law. And we need probably also to think about, because not every member state is still willing to do everything what we are thinking is a good way forward, to think about a kind of Europe of different speeds. Also here we need to come to solutions, probably what I would wish, but I won't have majorities for this. So I would like to concentrate all these administrations on one level, and then having a kind of a good balance between data protection on the one hand side and competition on the other hand side. If we are not achieving these, then there will be always too much data protection interference in competition probably. So we need to set priorities. What do we want to achieve? So AI is extremely important. We need to come up with more AI possibilities. Quantum computing, probably biotechnology. We are still leading, but we will lead in a couple of years still if we are not changing our approach on it. Robotic, why we are not concentrating more on robotic. So this might be all cases where we can play a kind of a certain role, but we need action management now in the Commission and not preparing too much papers and then discussing these for a couple of years in the European Parliament and elsewhere. And no, I think we need a plan. Let's sit together for 1 week, have a plan, strategy, and then execute it. And this is probably how we might still survive. I see this really in a kind of a danger right now, that we can be sovereign still. So we need an AI liability on a European level and not having a kind of a harmonized law, and if it's come to civil law, all of a sudden it's fragmented and there is no added value then for the companies. We need also to scale up company structures. So even if sorry, it's a long list I have.
I see the list.
Yeah. So we need a satellite system for military options, for civil communication. We need also probably to suspend some laws if we would like to win the transformation, like public procurement or some federal system elements. It's an old way of going forward, and now I would say the time has gone. Already we are in a position where we can't solve everything in a kind of beautiness. So that's why we need to come forward to take a risk on something. Even even I would say we need to restructure the Commission and also the Parliament in a way to solve problems. But of course, I won't have all the majorities for it. A lot of, I would say, colleagues are living in a kind of a comfort zone and not seeing the reality, and especially also in businesses where we are too much dependent. And and this is something, probably we can do something in agriculture instead of let farmers sit in the office. Why we are not changing these in health data and healthcare situations. Also in elements like security. Security is done today by analyzing data. Health is better with analyzing data. And this is what we should have in mind, and therefore we need a kind of a strong way forward, a management by the Commission, probably right now, thinking about European projects, because I see already member states discussing where are the working places and who's paying taxes to what country. This is not, so if we would like to concentrate on the third league, then we can move forward like what we are always doing. But if we would like to make a difference, a change, and orientating us more on a Champions League, then we need to act differently. Sorry for this long list of wishes.
Thank you. Yeah, I asked for wishes. Yeah, Alberto, Axel Voss mentioned a couple of points that relate to businesses, what companies should do, European cloud, and focus on certain technologies. How realistic is this, and what would your wishes look like, or your priorities look like for the next 5 years? Maybe in a short answer.
Yeah, so I think there's a lot on investment and what we need to do in Europe to be more competitive, have more champions in Europe, how we spend our money, public money. That's definitely one chapter. On the regulatory front, though, what's going to happen, and I hope we're serious about this, is that there's going to be a simplification element to anything coming out of the European Commission. So we know that there's going to be a data union strategy. We know there's going to be a digital package by the end of the year, possibly next. That's going to look specifically at solving the problems that we have identified so far, because one thing's for sure, we're going to have problems. We just don't know how bad they're going to be. Well, we know there's going to be problems. And now is the time to fix them. We cannot be acting as if we were 5 years ago, that we have just new laws and we need to see how they're implemented and learn, etc. We don't have the luxury of having so much time to waste. So there's a few things that we can look at, particularly on pieces of data legislation. Part of your first question was, how worthy are the goals of more data sharing, etc. We've done a lot of regulation around data sharing, and you explained this. A lot of that regulation is there's not enough data sharing, and I will be regulating you. I'll be giving you 127 rules that you'll need to respect if you want to share data. A lot of the regulation that we have doesn't really enable companies to have the legal certainty and the business acumen, the business case to be actually sharing data. Data Act, one clear example. Why do you need to force everybody with no differentiation be sharing data at the same time with the same modalities? AI Act, do we need to cover all these types of manufacturers at the same time based on one single law? Could we be simplifying that? So there's little things, I think, that are important to make sure that we have a clear picture of the big goals that we have. Other examples, and the GDPR is fairly little in this discussion because the GDPR will possibly be part of this data strategy or not. What we found out, given the wealth of new regulation that we have as businesses, is that the GDPR, at the end of the day, really is not the problem. The GDPR is a flexible horizontal framework that can be read one way or another. A lot of it depends on the goodwill of data protection authorities, okay? And probably there's a better dialogue that we need to have between data protection authorities and businesses to understand precisely what's worth doing and what's not worth doing. I would also be more favorable with respect to what's been happening in the courts. I think we have received quite a lot of positive clarifications, actually, from the Court of Justice around elements such as pseudonymization, anonymization, for example. A lot of those things could be part of targeted clarifications to the GDPR to clarify that, yeah, some things can be considered anonymous. Some technologies can be used to enhance privacy protections and therefore count as appropriate safeguards under the GDPR. We can't clarify how legitimate interest applies to things like security, to things like research, for example. We went through the European health data space. The European health data space doesn't even provide a legal basis for companies to process data for secondary purposes, precisely to do research into cancer, et cetera. It doesn't clarify the relationship with Article 9 GDPR and what exemption applies there. Why don't we clarify that through the data union strategy? So there's a lot of things that we need to do, and now's the time to do them, because the alternative simply is that, of course, there needs to be coordination. But again, the level of coordination discussion that there needs to be among too many authorities that we have now is simply too complex to guarantee that we'll have good results in 5 years.
Thank you, Roberto. And Wojciech, turning to you, do you agree with what our speakers said, and what are your priorities look like if you look into the next 5 years? What should change, and how do you see the future?
Well, I think what Luisa said about the need to know what the people think and what the people want is definitely something that should stay in our mind. Although we have to know that the answer is relatively easy and easy to guess. People want our data to be processed for the good of them and not for the bad of them. That's as easy as it can be. It may mean completely different things for different people. I would agree with Luisa that sharing the medical data, sharing the data about health is one of the most important things that we should think about. Well, having neurological problems, I'm one of the first in the row to share my data to find the solutions to that. But if I have mental problems, if I had sexual problems, probably my answer would be different. So once again, people want the data to be processed for the good, not for the bad. But the answers may be very different from person to person. The second thing which I would like to stress is what Axel said about our expectations to social media 15 years ago, and what we have at the moment and what we have the problem with the social media at the moment. I think that if we go with deregulation of the AI the same way, and we decide not to regulate it, we will wake up, maybe not in 15 years, but in 5 years, in the world where we will have the same problems with AI as we have at the moment with social media. So let's be careful with saying that we went too far with regulations. I'm not fan of all the laws that exist in the world. None of us in this room is a fan of that. But at the same time, the regulation for the sake of being deregulated is not the answer to the questions that we have. We should ask the people what they want, but we also should try to understand how the world is operating, because the social media is a very good example. We think about TikTok, we think about X, we think about Facebook, but we don't know that for our children, the social media are the things like Genshin, for example. And there's no answer if Genshin is the social media according to the laws that don't allow the children to use the social media in the countries like Australia, for example. So we have to understand what's going on around, and we should give the answers which are relevant to the questions that we have. That will not be binary answers. I'm not surprised that we still don't know what is the personal data. The things are more quantum, yeah? That's not binary. It's still something in between 1 and 0.
Thank you very much. So it's your turn now. Who wants to ask the first question? And question to the organizers, do we have microphones, or just speak up loudly, then we will understand you. Was there a question? Come on. No questions to anybody here? That's your chance.
I'll take the first one.
Yeah.
Discussion very enlightening.
Can you please just briefly introduce you very quickly?
Data Protection Officer of CFE. So first of all, what I like most here is that everyone shows a sense of urgency. Something needs to happen. So that is very clear. But we see a lot of different approaches on this one. That's competition, probably also at its best. But on the other side, I have a very concrete question. I liked the one statement by Luisa Specht-Riemenschneider in the beginning, saying we need to turn what we have, the GDPR, into a competitive advantage. So I'd like just to hand back the question and hear your ideas how we could do that. How could we make this, the GDPR, the good things about the GDPR, in light of all the cumbersome effects that it also has on the economy, how can we make this one as something that makes people worldwide choose European products over international products?
Shall I take it? Yeah, thank you so much, Matthias, for the question. I think it's two things that must happen. First is with us, with the regulators. I think our guidance is good, but it can be more concrete in one or the other situation. And I think we need to think about new instruments of giving advice and giving information. Maybe I have to admit these instruments may be just new for me, because I think you do the sandboxes, right, Wojciech? You do that at EDPB? Okay, but ICO does that, and I have read about 2 or 3 other regulators who already have sandboxes, who are already doing sandboxing, and sandboxing to me is really a great instrument to give more concrete advice. Being a regulator, we can have a chat on that later on. I don't want to annoy everyone in the room because I'm speaking too long here, but new instruments which help to give more concrete advice, which make the people who want to comply with data protection law be able to comply with data protection law. And when we get into a situation where this can really happen, then you are in the situation to really comply with the law. And if you do that, I'm really of the opinion that people who can choose between a digital solution who has lots of data protection in it and a digital solution who has not, they will choose the solution with the data protection in it, because data protection is trust. And then we could really have a big advantage also in the market, and then we can have a unique selling point.
If I can add just one sentence, that would be that we should not, as the data protection regulators, choose between European solution and non-European solution. We should choose about the solution which uses the values or respect the values that we have in Europe. But it really doesn't matter if this is Vietnamese, or it is American, or it is Australian, or it is from Europe. If it is something which preserves the values that are in the core of the EU, that would be acceptable for the regulators.
Luisa, may I ask a follow-up question then? You said we need precise guidance from the regulators, and I fully agree that it needs to be coordinated and needs to be precise. But when we then look at the uncertainties around, I come back to this topic all the time because I have it on my desk every day, concept of personal data, or what is anonymization. Is it realistic that we see one day a coordinated guideline from the European regulators which has clear use cases that companies can rely on, where the risk analysis that is behind the question what is personal data and what is not, according to the European Court of Justice case law, is broken down into examples, or anonymization techniques are accepted in such a paper, which can also be realistically implemented in practice. I think that's how we need to start. That's what companies need to really start to see the benefits of the GDPR, to have legal certainty, and then all the competitive effects may come in the next steps. I think that is what we definitely need, and as Alberto said, it's about the law can be applied that way or the other way. The GDPR is very flexible. Recital 26 is very clear in my view on the concept of personal data. The GDPR, the European Court of Justice case law, 80% at least is also quite clear. The other 20 not so much. And but the regulators' approach is what counts at the end of the day, yeah. Because the companies look at the regulators and they fear the regulators, and if they have some certain legal doubts, they say, okay, we treat everything as personal. What else should they do? So it's really difficult for companies that want to be compliant, and that's where we need help from you, from the regulator side.
Well, I agree in the goal. We need clear guidance. We also need clear laws, and I see different actors with different instruments. There is the legislator, who I think can also look into some of the digital acts, especially in the DMA, the Data Act, the Data Governance Act, etc., and be more precise. And then I see our role. I'm always asking, what can we do better? And I see that we have different instruments. We have the instrument of guidelines, who will always be on a certain abstract level, because we have to find compromises, because we have to address many issues in these guidelines. So it is not possible that the guidelines will come down to one single question, I think. But there are other instruments which I think we can also use besides the instrument of guidelines. And the first is concrete examples. We in Germany, at the moment, we are trying to really give examples on the pseudonymization guidelines within the Data Protection Conference, and have different examples on how the guidelines are meant. Berlin is in the lead. I think this is really a good way to go. And there is the instrument of sandboxes, where regulators can really look at a single case. You, being a company, can come to the regulator who offers sandboxes. You can tell us, well, we want to have an AI who's doing that and that and that, medical research. Then we try to give guidance on how this AI can be implemented. We look at it, you follow the guidance, we look at what you did, then we say, okay, maybe a bit more in that direction or a bit more in that direction. And in the end, there is one AI who is compliant with data protection law, and who functions, and which functions, sorry, not who, which functions. And this is one single case which has guidance then, but what is also being given in a sandbox is that from this case, there is being given guidance which can be applied to other cases also. So there is really big space for doing those sandboxes, and as Klaus already told, there's also the space to have coordinated guidance from different authorities.
Let's be frank. There will not be the situation where we have the guidelines for everything and the guidance from the regulators on everything. When we worked on the GDPR, there was a great call: do not over-regulate. Just give principles. We know how to deal with them. We know how to be accountable. When GDPR went into force, there is a great call: where are the guidance? Where are the templates? Where are the checklists? And the answer is there will be no checklists, very few templates, and there might be some guidance. But the guidance will not solve the problem, because the differences that exist between the countries. And Axel said very wisely about the problem of AI and liability directive. After all, the civil law is not harmonizable for AI. That's what we got to know. And the same way, when we as Data Protection Commissioners started to discuss about the guidance on CCTV, we found out that there is a border in Europe where on one side the police is recommending to use the dashboard cameras in the car, and on the other side of the border it's a criminal offense to have one. And this is the border which is in the Schengen area.
I'm asking myself more and more, should we not move away from data protection to privacy protection? It might be problematic also define what is privacy at the end, but some data, from my understanding and approach, doesn't need to be protected. But that's why I think it would be probably a good way forward, and this is the sense behind privacy protection, why we are not going into this direction, and then hopefully it makes life a bit more easier. I have other ideas in changing GDPR. I don't want to mention this now, but here this might be a way forward, because what is all about is the privacy of our citizens and not the single data at the end. So that's why I would make this kind of proposal to think about, and probably it might be a way forward.
So to Matthias's question, I think a key part of everything is trust. You would assume that a European company should be able to go to their national regulator, discussing in their national language, in their national market as a starting point, and not having the impression that they walk into a lion's den. So there should be genuine dialogue, and I think the attitude that DPAs go into a discussion with companies also needs to be a little bit more service-oriented. DPAs, at the end of the day, are also there to help support companies to figure out how to still go about what they must be doing based on their right to economic activity in a way that complies with the GDPR. So they need to be able to help them. And in many cases, we actually see the opposite. I have a horrendous case of a company, who I will not mention, a German company though, German regulator. And they went to the regulator and they said, I have this wonderful use case. They thought they were doing the right thing and doing PR with the DPA. I have this wonderful use case. I'm going to use anonymous data to do A, B, and C. And the reaction of the DPA was not to ask, are you sure that the data is really anonymous, which I would have understood as a question, but the reaction was, wait a second, do you have a legal basis to anonymize the data? And that is indicative of a negative attitude that sometimes we see in these discussions. And I think European companies normally should be the first to benefit from better dialogue, because they should know their regulators better than non-European companies.
There's one more question over there, maybe the final one, looking at the time.
Yes, hello, thank you very much. My name is Anne Hansen. I'm from Fraunhofer in Germany, from the Data Protection Office. Wonderful debate. Many things were already said, but Frau Specht-Riemenschneider, before you said something very important, I think. Trust is data protection. And when do I have trust? I have trust if I'm transparent and accountable. And actually, now it was already debated thoroughly what you said about the vision, and I think the point is very correct, that we all have different visions of the no-goes and what we won't accept. Let's discuss it anyway, because of course it allows us to form a joint opinion to some extent as a group, as a society. Nonetheless, the remarks about deregulation and having to do something now, I think many of us feel like that also from the hardcore data protection junta that I count myself a member of. But could we maybe explore a functional approach where we look into what is actually providing accountability, what is fostering transparency? I mean, a 15 pages long informed consent obviously isn't. So let's get rid of that. Let's have some of that actionism, but let's please not only do the thinking from the end when we apply the GDPR, let's also regulate like that, or enact new legislation, because we have a massive quality issue, and many PhDs, I'm sure, can be written on how to solve it, but we could also maybe identify core principles like transparency and accountability. I'm not talking about the no-goes and also not other kinds of categorizations, but really the functional preconditions for having trust, and then look into, on a legal, legislative craftsman level, how can we have provisions to foster that? Because I think we could easily agree on that on a European level. And if we have predictability, then there are so many problems going away. I can just say, as a practitioner, consulting many research projects in that case. But would you think that a functional approach could also work? I don't know who to ask.
So whom are you asking of our panelists?
Maybe Mr. Herrmann, from the academic point of view.
Of course. Sure. I'm trying to get grips with your functional approach. If I understood you correctly, then the functional approach is somehow more clear on defining what is allowed and what is not allowed, and I understood that it's combined with reducing, for example, information duties or other duties when drafting data protection notices, for example. So I'm not too sure whether I'm fully getting grips with your proposal, but I would be in favor, as we've heard before, that we more clearly define what is allowed and what is not allowed. It is true that the information duties are long, but probably necessary in order to inform yourself. I'm not too sure whether they are in practice always necessary at the actual moment when you consent or when you get it. Also, it must be sort of an informed consent, but they might be important when you're trying to enforce your right to have them in order to have an indication about the legal justification and all the other information provided. So I wouldn't be in favor of reducing the information aspect totally. I'm not sure whether I fully sort of grabbed your entire proposal, but it leaves me the chance to just add one other aspect, which is also linked to the first question, which is the fact that obviously, and as you have also pointed to, trust is extremely important. And having sort of the societal dimensions of data processing, having the geopolitical framework, one major aspect we will discuss within the next years is the question of data transfer rules. And if we look at the proposal, the consultation, the European Commission has also pointed to an international data strategy also for non-personal data. And these questions regarding the transfer to other parts of the world and the trusted partners and the not trusted partners will go on and are mainly very much interlinked with the element of trust, to pick one aspect in this regard. Thank you very much.
So thank you very much. I'm sorry, but we have to close the panel. I think we could keep discussing quite through the night, but we have one more speaker here, and we also want, obviously, to meet up afterwards. So, yeah, thank you very much to all of you. Thank you for coming.
It is a long evening, so we are almost at the end of this debate, so thank you very much to all panelists. So let me please call on the stage Thomas Petri, Bavarian Data Protection Commissioner, who will offer a final reflection on tonight's discussion. Mr. Petri, the floor is yours.
Dear colleagues, dear guests, the most important rule for closing remarks is keep it short. Give me a try. Joachim Herrmann reminded us at the start of today's event that GDPR and the EU Digital Rulebook must go or should go hand in hand. I would like to thank Alberto Di Felice in this context for his depiction of the considerable challenges for European companies, not only in the digital sectors, are currently facing. Maurice Hennemann guided us through some potential pitfalls in the relationship between the GDPR and the Digital Legal Acts. And he misses the he stated a lack of incentives. I'm very grateful to Katarzyna Prusak-Górniak, I hope it's right, okay, for kindly allowing us some insights to the engine room of the European legislation. And I'm wishing you and your colleagues all the best for the complex tasks in the future. Axel Voss sees the need of a good balance between digital development on the one hand and the data protection on the other hand, and what he wants is action, and he wants action now. Of course, we should take some promising recipes for success from today's evening, and that should allow us to meet these challenges. As a Data Protection Commissioner, I'm dependent on a good relationship with my colleagues and my partners in other supervisory authorities. So I'm very grateful that Klaus Müller told us his ideas about cooperation between supervisory authorities. My colleague Luisa Specht-Riemenschneider came from the fundamental rights-based approach and picked up a thread again from the perspective of a data protection authorities, and her recommendation is, for the future, make a good plan and then go. Now, what can cooperation look like in the day-to-day work of supervisory committee authorities? Wojciech, I'm sorry about the name, I hope I said it correct. Wiewiórowski has presented first his project for a digital clearinghouse 2.0, and we should use solutions which represent the European values. It's not important to use European products, but use products which represent the European values. That is a very remarkable recommendation in this point. In addition to improved cooperation, Irene Nicolaidou kindly has given us an overview of the measures already taken within the framework of the European Data Protection Board. And with all these ideas in mind, I'm very confident that competition and innovation and data protection will continue to go hand in hand. Finally, I would like to thank the moderator of the panel, Ulrich Baumgartner. Thank you. You're safe in the Bavarian soil. Who guided us through the discussion. And a big thank you also goes to Armin Hartmuth and the whole team at the Bavarian representation in Brussels, and the teams of the co-organizators who have welcomed us today and make this event possible. Thank you very much. And now, the most important sentence, I would like to invite you to dinner and wish you further exciting discussions. Thank you very much.